I don't get this.
Of course, calling your supervisor a jackass to be protected activity, among other things, using racial epithets in the workplace to be protected activity. And, you know, you call me and say, really federal law concerned with these types of things? And I, again, have to explain to the NLRB, they've declared student athletes at Northwestern to be employees rather than students. What else? Oh, they allowed picketing on site at your hospital. That's always great for patient interactions and relations, right? When there are picket signs, when people are coming in seeking care, that always gives them a good welcoming feeling. What else? They certified these micro units, the perfume counter at Macy's, the people who work in the fitting room, that's an appropriate bargaining unit as a group that can be unionized. And what else? Handed over your computer systems to organizing and never really agreed with us. As someone who's worked on the side of the NLRB, I can tell you it's a pretty small universe. I remember I came out here to work in Denver, and I had been in New York City, and I moved out here, and I met everyone in the office, and they were all very nice. But over time, I began to realize that they have a very limited area of experience, that particular law. They don't know about your business. They don't know about the types of challenges you face. They don't think about the fact that you're not going to twist your mustache, I'm sorry, David, in an attempt to come up with to violate employees' rights. You know, but that's the perception on the inside of the NLRB is that we're somehow out to get employees or we're trying to discriminate. So that's what we've been dealing with until what happened here? Is this one dead?
What the fuck?
The next one.
There you go.
It's very dramatic. Until this year, which is the best year ever at the NLRB, essentially. That's what I'm calling it. The NLRB at the beginning of 2019 started issuing decisions that radically changed the landscape. A couple of things about these decisions. They've not only corrected some of the recent, what we consider to be missteps of the National Labor Relations Board during the previous administration and during the previous board, they've also revisited decisions that have haunted us for decades. Like the idea that you're always required to allow a union organizer to access your cafeteria. Hey, Liz. They've enraged the labor movement like never before. Basically, I have clients now who talk to me about the fact that unions don't want to go to the NLRB because they feel like it's becoming so hostile to the labor movement. The one thing that is sure is that once this NLRB has moved on, if any of you have experience with this agency, you know that it swings back and forth from Democratic to Republican administration in terms of whose interests it's most aligned with. You can rest assured there's going to be a massive retaliation. Okay? After there's a change in administration, the new NLRB will be rolling back a lot of these things. So you have to enjoy these cases while we can. So I want to start at the beginning of the year, January 2019. Some of you have heard about this case, probably the most significant employee decision or decision about who is an employee before the NLRB. And this is how it's sort of organized cases, who's an employee, who's an employer by topic. So the employee, most significant employee decision was probably Super Shuttle. It was issued in January. Actually, the case was litigated by this law firm in 2009. All right, so 2009, the regional director in Dallas-Fort Worth declared that the Super Shuttle franchisees were independent contractors and not employees. It stayed on appeal for 10 years until the decision was issued in 2019, upholding that decision as independent contractors, which that alone is enough to turn you off to the NLRB, right? That, you know, having to keep an attorney engaged for 10 years during an appeal. But what's significant about that is that the labor movement really talks about this decision as a sea change in terms of who is an independent contractor, who is an employee. In fact, while it was on appeal, there was a union-friendly NLRB in place that could have overturned the decision and did not. Because it's really not that big of a correction. Really what Super Shuttle is about is a reestablishment of the traditional control test for independent contractors. By the way, if you have any questions, just interrupt me. If you're on the phone, there's a way to email questions in, correct?
Yes,
and I'll try to answer those on the fly. So there was a very angry dissent. There was a lot of controversy about Super Shuttle, but again, it is really not a significant change. But I think that, you know, what's important about that case is that everywhere else seems to be running in the other direction. Some of you may have heard about the Uber tax bill in New Jersey. What was it? $678 million. I'm from New Jersey. Everything's illegal in New Jersey. I just want to point that out. So would you learn that very, young in school? They say you can't do anything in this state, so just get used to it. But that tax bill, right, is an indication that New Jersey views Uber drivers as not independent contractors, as employees. So really, the NLRB is going in a different direction than some of these states. California, obviously, is a huge example, finding more workers to be employees rather than independent contractors. And in my experience with the board's view of this issue is you're just telling people they're business owners. That's not the reality. But I can tell you from experience, at least in my experience, in the super shuttle cases, is that those folks wanted to be independent contractors. They wanted to be independent business owners. They owned their vans. They owned multiple franchises. So, again, a lot of misperception. Recently, in the Velox case, the NLRB reaffirmed the super shuttle decision, but also pointed out that it's not an unfair labor practice for you to get it wrong, employer. If you make a mistake, that's okay. It really bothered me when the NLRB started saying, we're going to start finding violations if you incorrectly classify your employees. Again, that's a perception thing, right? They perceive employers to be trying to find out ways to stomp on employee rights. None of you are like that. And so the NLRB has recognized that and said, if you get it wrong, that in itself is not going to be an unfair labor practice. Also on the employee issue, the NLRB issued a rule in September saying that we're not going to consider graduate teaching assistants to be employees. They're students. And there was a lot of hullabaloo about that. The truth of that case is that since 1974 up until 2000, graduate teaching assistants were considered students by the NLRB. Multiple administration, the Carter Board, even found that. So that's not that big of a change, but again, the hostility towards the NLRB changing some of these rules, and that is issued via a rule. So in other words, it's not a decision that can be simply overturned or challenged in the courts, although I would suspect that there will be a challenge of that rule. So turning from employee issues to the employer issue, the NLRB issued some decisions concerning who's an employer. Again, this goes to this issue of control. Most of you have heard about the joint employer issue. I talked about it earlier, that this idea that under the previous Obama NLRB, that if you had a business relationship with another company, you could be considered a joint employer with them because they were relying on what's known as indirect control. This idea that you could have the right to say, change this term or condition of employment, whether or not you exercise that right with respect to your business partner, that other company. So if you had something in your master service agreement that said comply with all labor laws, would that be enough for joint employment status under the old rule? Probably. So that was the BFI decision that was overturned briefly by the Highbrand decision issued by this NLRB. But then the NLRB had to retract that decision because member Emanuel, his old firm, Littler, represented BFI. So they pulled that decision down, and in the meantime, started thinking about issuing a rule, again, on this issue of joint employer. And the current NLRB's view, to our delight, is that you have to demonstrate active, immediate control over terms and conditions of employment, co-determining terms and conditions of employment. You have to show that the other company actually has some say over it, not just the potential to say anything about terms and conditions of employment, and that's what the rule says. Unfortunately, while the NLRB was formulating this rule, the DC Circuit, the Court of Appeals in the District of Columbia, issued a decision essentially upholding BFI, but saying, look, NLRB, you're going to have to clarify the difference between a basic business provision in a master service agreement, right, or in a business contract. You're going to have to distinguish that from something that shows joint employment status, because we can't figure it out. Which I think is a good indication, and something that we've all been concerned about, that this rule is going to clarify that we're no longer going to look at sort of boilerplate contractual provisions as showing us to be joint employers. And this has wide-reaching implications. This rule will be out, will be finalized this year, and I think, again, a very positive development for us, because what's the importance of joint employment status? If you're a joint employer with some other employer that's violated employee rights, what happens to you? You're held liable for that, right? So that's why it's significant. Also, you can be brought into union relationships that you're not a part of by that rule. So moving on from the employer issue, one of the things that's always confounded employers over the years is this idea that the NLRB has some say over your property rights. Okay, I'm here to tell you that the National Labor Relations Act, I'm pretty sure when it was passed in 1935, Ray's here, so he has firsthand knowledge of this, sorry, is that they didn't say anything about property rights in the NLRA itself. Is that right? They didn't.
My best recollection from that year.
Yeah, it's that they didn't say it, right. So they didn't say anything about property rights. What the NLRA did was they gave employees the right to engage in union activity and protected concerted activity. And the idea that the NLRB could say something about your property rights derives from the idea back in the day when employees could not hear the message of a union organizer unless the union organizer could come onto the employer's property, right? Think about like fish camps or the North Slope of Alaska. There's no way, in the old days, there was no way for employees to hear about their rights or about being able to join a union unless you allowed unions to come on the property. That's where this all comes from. And in recent years, it got sort of demented into this idea of balancing, you know, are we going to allow the union organizer into your public access cafeteria? Because we're supposed to balance employer property rights against employee rights to engage in protected concerted activity. Thankfully, the current NLRB has sort of scaled a lot of that back, and the really significant decision for healthcare providers is in the UPMC decision where the board said, look, historically we've said if you have a public access cafeteria, you have to let the union organizer on, but that doesn't make any sense under this line of cases that talks about when you have to give up your property rights in order to effectuate employees' rights to engage in union activity. So you don't have to do that anymore. If someone's coming on to your, into your hospital, going to the cafeteria solely to organize employees, you can exclude them, all right, which is a huge development. Almost immediately thereafter, or a couple months thereafter, the board set back another sort of demented idea about employer property rights, this idea that was in the New York casino case that said if you have a contractor that comes onto your property to do work, that those contractor employees think, the carpenters who come onto your property to do a drywalling job, right, if you're a non-union employer. If you have that contractor come on, you must let those employees and their union organizers or whatever have access to your private property to engage in protected concerted activity. Again, based on this idea of when you have to yield your property rights, which doesn't apply, right? How many ways can a union organizer contact your employees today? Think about it. Most organizing drives that I experience are done on a smartphone. That it's a private Facebook page, or it's a Twitter feed, or it's some sort of email trick. People aren't, marching onto the property. That's not the only way they talk to your employees. If that's the only way they talk to your employees, they're not going to be very successful at organizing. Okay? So in the Bexar County Performing Arts Center case, the NLRB said, we're not going to, if you have a contractor come onto your property, you don't have to open the floodgates to the union organizer coming on. This involved a protest that was the Federation of Musicians against the San Antonio Symphony. And the symphony was a tenant of this Performing Arts Center. And the NLRB said, look, you don't have to allow them to come onto your property to engage in this protest and picket and say that the symphony is unfair unless they are regularly on your property and they have no other means of contacting your employees. So going back to the traditional rule, do they have other reasonable alternative means of talking to the union? If so, you don't have to cede your property rights. Finally, and maybe the most significant decision, the Kroger case, the NLRB said you don't have to open the floodgates to union solicitation if you have other types of entities invite them onto your property for the purposes of charitable giving or, the United Way. And I worked at Anheuser-Busch in-house for a while, and we spent days debating whether or not we were going to allow, the Urban League onto the brewery property to talk to some people about their initiatives, because we were concerned that if we did that, we were going to do what? Let everybody on, right? Open the floodgates, before, if you have like Scabby the rat, coming onto your property, or there's, whatever it is. So we had to talk about those things and think about how crazy that is. The employer is thinking about ways in which you can be involved in the community, right? Have engaged community organizations, maybe engage in charitable work, and they have to think about ceding their property rights. And so finally, the NLRB agreed with us and said, we're going to not look at whether or not you open the door to anybody, but whether or not you open the door to a like type of solicitation. If you do that, someone who's soliciting membership in an association that, requires dues that's similar to union organizing, then of course, yes, you have to let the union organizer on. But if you don't do that, you're not going to open yourself up. So that's good news on property rights. We always talk about, and there's all these writing and articles about the fact that, the thing I said about a jackass, I always I speak a lot about the NLRA, and I always my go-to story is this idea that a group of employees got together and on Facebook, and one of them called the supervisor a jackass, and everyone else, gave it the thumbs up. I'm not on Facebook, but, like a like, right? And the NLRB said, oh yeah, liking that's protected concerted activity, and calling your supervisor a jackass is part of what we're here to protect as an agency. And, people laugh about that, and they say, that's ridiculous. I mean, to me, I don't view, I take this, I'm a supporter of this law. I'm a supporter of this agency. I fight against this agency all the time, but when they talked about closing the Denver regional office, this firm, and Ray and I and other lawyers stood up for this regional office and said, should keep it open. But when they start talking about insulting people in the workplace as a form of protected concerted activity, it offends me, okay? This law is about the idea that employees have the right to bind together to affect their terms and conditions of employment. It's not about whether or not they get to insult people or start a fight in the workplace. So anyway, I'll get off my soapbox. The first big, right after the Super Shuttle decision, the NLRB issued this decision in all state maintenance that some of you may have heard about. That involved the JFK Sky Caps, and they didn't want to help out the French soccer team because the French soccer team doesn't tip, which is good information for all of you to know that they're not tippers if they involve any kind of service. So at least if you leave here with anything, you know that French soccer teams don't tip. But the Sky Caps didn't want to help them out because of that. And the NLRB said, you got to look at whether or not there's actual activity for mutual aid and protection. Someone saying, hey, look, I don't want to help them, I'm not going to do this, is not going to be automatically protected concerted activity. Look at what's happening. Are they trying to act together for mutual aid and protection? Are they talking about their terms and conditions of employment? That's what we should be looking at. In a very recent case, actually, issued a few days ago involving Amnesty International, and the labor movement has gotten into this mode where it's sort of organizing its friends, which has led to some interesting cases. The folks it perceives as its friends, and they assume that their friends or employers will invite them in. So Amnesty was dealing with the union organizing campaign, and some folks just tried to act on behalf of unpaid interns who were not considered to be employees. And the NLRB said, that's not protected concerted activity because it doesn't concern employees. We're here to protect employee rights. Employee rights. So the other big decision in September and October, the NLRB finally said, we're going to look at this issue of whether or not racially offensive conduct or words or insults, when they lose the protection of the act, and we're going to try to apply a rational view of that. And I think it's about time, right? I mean, it's about time that the NLRB said, we're going to stop just assuming that you curse out your work for you. I mean, literally, there are cases where there's someone utters directs a racial epithet at a supervisor and other employees join in, and the NLRB has found that to be protected. So the NLRB is now going to take a look at that. They've invited briefing, and guess who submitted a brief on that? Your old friends at the EEOC. Okay, the EEOC said, you need to do something about the language in the workplace. Okay, you need to ensure that people are not subjected to these types of comments in the workplace. All right, so the EEOC, that's how crazy it got, right? The EEOC is on our side, arguing against the NLRB, saying, you're way off in saying that this type of conduct is protected. So read that EEOC brief, especially if you're having trouble sleeping. But no, seriously, it's very, very instructive because it talks about the laws that you all deal with more than you deal with the National Labor Relations Act, you know, protecting employees from discrimination, from offensive conduct in the workplace. The other significant decision was the LA Specialty Produce decision that came down, and this addressed the fact that when we read about these rule cases that the NLRB had issued over the years, we kept saying to ourselves, what's wrong with this rule? You know, not just the civility rule, but what's wrong with saying that we get to speak to the media on behalf of the company? What's wrong with that? You know, and somehow the previous NLRB said that your average employee, my partner John Doran calls this the biggest idiot test. And he says that, you know, that they have this tortured reading of these rules to conclude that employees might feel chilled by the idea that they can't go directly to the media because they've interpreted something that says, we speak to the company on behalf of the media saying you can't, which of course it doesn't say. And so in the LA Specialty case, the NLRB said, don't engage in this tortured reading to begin with. Look at the actual rule. And if the rule doesn't directly address what employees can or can't do, it's not appropriate to read into that rule a restriction of employees' rights. Duh, right? So they looked at a media contact rule and a confidentiality rule, and they said, we're not even going to engage in the analysis of whether or not this is a lawful rule because no reasonable employee could read it and find it to violate their rights. So again, a huge correction, very helpful for us. So the other thing that the NLRB has recently done is that, you know, the NLRA had two policies when it was passed, two primary policies. The first one is supporting the right of employees to choose whether or not to engage in union or other protected activities. The second policy is the promotion of collective bargaining or labor peace, if they do choose union. So on this issue of do employees have the right to choose, this NLRB has been very concerned that the decisions over the last 30 years have chipped away at that right to choose. I'll give you an example of that. Sometimes, I know it'll be shocking to all of you, sometimes your employees decide they don't like a union and they want to decertify. Okay, historically, the way that works at the NLRB is a group of employees get together and they file a decertification petition. What happens immediately after they file that decertification petition in every case? Yes. What does the union claim?
That the employer coerced
That the employer, see, well, Carissa's here. Carissa helped me with this presentation. Carissa Davis, our new associate in labor and employment. She, of course, is the ringer in the audience, and she says they immediately claim that the employer initiated this decertification effort. And the way they do that is they file a charge immediately saying, you know, that you initiated this. You should dismiss this petition. And historically, the way that's worked is that it delays the election of the employees who are trying to get out. And what happens? The union goes out and they try to win them back, right? Which, of course, you would expect them to do. But in the meantime, I've had cases where a year has passed between the time that those employees said they wanted to get out and because of this blocking charge rule, that basically there's no vote. And then when there is a vote, everyone's all forgotten about why they were mad about the union because now they got like the union jacket and stuff and they've been to a few cookouts and they're good. All right. So the NLRB has started addressing these types of things and said, we're going to put employee choice first. And a couple of ways they've done that. The Johnson Controls case involves a unionized employer. If a unionized employer gets notice of disaffection with the union prior to the expiration of a collective bargaining agreement, the unionized employer can withdraw recognition. And it's called anticipatory withdrawal, which is, you know, just rolls right off the tongue, right? And historically, the unions have been able to come in and prove through an unfair labor practice proceeding that they still represent employees. So the NLRB said that doesn't work. Why don't we say that if the employees want the union to stay, that they can have an election, and we'll run a secret ballot election. Historically, the NLRB's secret ballot election has been the one thing that people don't criticize about the NLRB. Employers, unions, they all think it's a good thing. Recently, I've heard some union criticism of the NLRB election process. But having run an election myself, or several elections myself, I can tell you, it's a good, clean process. It really gives employees a private right to choose. So Johnson Controls says, if you do that, you get a vote. You get a vote if there's a withdrawal or there's disaffection. In the Cisco Grand Rapids case, the NLRB said, even if you, employer, have committed a bunch of unfair labor practices in response to a union organizing campaign, we're not going to order you to bargain with the union if a lot of time has passed. Okay, I've had organizing drives where there's a bunch of unfair labor practices filed by the union, and 3, 4, 5 years passes, and then the NLRB says, well, those folks still want the union, and so you have to bargain with the union. 5 years later, 50% turnover, it's a completely different workforce. So the NLRB is going to look at the current workforce to determine if a bargaining order is appropriate. They have a proposed rule on employee choice that was recently issued, where they're going to change their approach to the blocking charge rule, which I talked about in decertification, but it also applies to cases where employees are trying to bring in a union. If employees are trying to bring in a union and the union perceives some unlawful conduct on the part of the employer, the union can file a blocking charge. And what happens is the election gets delayed. The NLRB has now said, we're not going to do that. We're going to let people vote. We'll impound the ballots. And then after the illegal activity is investigated, we'll open the ballot box and we'll tell you what the result is. And then finally, in the Boeing company case, some of you may have heard of the PCC Structurals case, where the NLRB said, we're not going to allow unions to organize in micro units anymore. They said, you got to look at the people who are excluded. So, think the Macy's, I always say the Macy's perfume counter is actually, I don't know, like 18 or 20 employees in a huge department store that the union organized. We're going to look at actually whether or not you're excluding employees who should be included in that bargaining unit. That's what they said in PCC Structurals. But the reality of dealing with the NLRB day to day is that at the top you have these decisions. But who employers and unions and employees deal with day to day at the NLRB are the regional offices. And who's in the regional offices? People like me, okay? Who am I? I'm somebody who was a community organizer out of college in the Bronx. Okay, and then I went to law school, and then I joined the NLRB. Do you think that I'm going to have a real open mind when it comes to employer issues? The answer to that is no, I didn't, okay? I thought all employers were trying to violate employee rights. So at the regional level, the board agents are going to be less inclined to agree with what's happening at the top level. So the dynamic of what happened with PCC Structurals is that the regional offices didn't apply it. They didn't apply it. They didn't say we're like, they kept, certifying these micro units. So the board in Boeing said, you're doing it wrong. You're doing it wrong. You've got to look, and in that case, there was a small group, 2 groups of maintenance employees, I believe, at Boeing, and a huge sea of employees. And they said, you can't certify these people and balkanize them from the rest of their employees. You have to look at whether they're functionally integrated. You have to look at whether they have same terms and conditions of employment. So they slapped down the regional offices. We'll see what happens. But again, that was a good decision for us. Another thing that employers got really upset with the NLRB over the years is the NLRB goes into all areas of the law and assumes they're experts. Remember how I said that it's a very insular community and they don't really get out much and they don't really know what your issues are? Somehow, we've had regional offices ruling on state law. Well, this state law means this, therefore, you're wrong, employer. Or the Federal Arbitration Act. That doesn't override our jurisdiction. The NLRB, and really the NLRB is shrinking, right? When I started working in Denver, there were 40 agents. 40 agents. How many are there now? Nobody knows that except for me, right? There are 7. 7. I'm old, but I'm not that old. I came out here in 1996. Okay, so think about that. That's a precipitous decline. So the NLRB have been really looking to expand their jurisdiction, get into that. That's why student athletes became employees. That's why they started talking about arbitration agreements. That's why they started combing through your rule book. When I worked at the NLRB in Manhattan, we would get an employer handbook and we'd say, if we could find 100 violations in this thing, if we wanted to, if we had the time, okay, now they have the time. So the new NLRB has looked at ways to sort of curtail this trend to go outside the NLRB's historic jurisdiction, which is really about the exercise of the right to engage in union activity or other protected consumer activity. The Cordua Restaurants case is the first case that the NLRB addressed the Epic Systems decision from the Supreme Court and said, not only is it not a violation of the law to require a class action waiver in an arbitration agreement, but you can promulgate such a restriction in response to a bunch of employees going out and trying to organize a class action wage and hour case, okay? Which is a huge development for us. So it really gives employers more flexibility, again, staying out of the lane of where the Federal Arbitration Act should govern. The Ridgewood Healthcare case, health center case, involved the fact that historically, when you acquire a unionized employer, if you're a non-union employer, you typically have the right to set your own terms and conditions of employment. But you lose that right if you try to avoid the union, okay? That's like getting, you try to stay out of the union relationship, and the historic remedy that the board has imposed is that you get the union relationship and you have to comply with the collective bargaining agreement of your predecessor employer. So the Ridgewood Health Center case said it requires a little more than just a simple violation of the act. You have to actually demonstrate that the employer has the scheme, right, to avoid hiring the predecessor's employees. And then in the United Nurses case, the Kent Hospital case, the NLRB said this whole idea that in a union security state, a union can charge you for its lobbying expenses. And by the way, Colorado permits union security, that is forced payment of dues as a condition of employment. Requires a second election, but it's allowed in the state. And unions are only supposed to charge people who don't want to be a member of the union representational fees. So unions were charging lobbying and things of that nature, and the NLRB set that straight as well. So probably in the best news ever for all you unionized employers out there, I don't know how many there are, the NLRB very recently reset this idea that a collective bargaining agreement can only waive employee rights if it is a clear and unmistakable waiver. So basically what used to happen, and when I worked briefly on the union side as well, and I can tell you that unions have very limited resources. And what is the one thing about the NLRB that unions don't have to do when they file a charge? The NLRB is paid by whom? Us, right? All of us. Our tax dollars pay for the NLRB. When they prosecute employers for violating the act, we pick up the tab. Okay, unions don't have to pay for that. If the union is going to an arbitration under a collective bargaining agreement, they have to pay that. They have to pay their attorneys, they have to pay the arbitrator, right? So historically, what unions have been able to do is, even if they have a collective bargaining agreement with an employer, if the employer makes a change, the union will file an unfair labor practice with the NLRB and also file a grievance. So they have this, two-pronged attack. And we're always trying to get them to arbitrate the grievance because that requires them to do what? Pay, right? And therefore they have skin in the game. And they might consider some of the things we have to consider, cost benefit, do I want to? And when we used to say in the old days, 2 years ago, we used to say that we have a collective bargaining agreement. We're allowed to do this. This is our management right. We can promulgate this policy. We can institute drug testing. We can, change our attendance policy. We can say that you can be disciplined for tardies. The NLRB will say, well, yeah, I see a management rights clause, but has the union clearly and unmistakably waived the right to bargain about changes to the attendance policy? Okay, that phrase, clear and unmistakable waiver, sounds as difficult as it is. It's almost impossible to meet. Okay, because all the union or the affected employees have to say is, we didn't talk about attendance policies when we talked about policies that the employer made. We were thinking about more their business policies, right? About what businesses they got into, not attendance policies. And so it created this situation for us where we had to fight the battle on two fronts. So in MV Transportation, after many, many years of this going into the Supreme Court, the NLRB finally said, we're going to adopt a more rational test. That is the contract coverage test. all right, we're gonna dispense with the clear and unmistakable waiver test because you can't meet it. And we're gonna say, if you have a contract, management rights clause, or provision that deals with this topic, right, it'll give effect to the plain meaning and the relevant contractual language and find a change covered if it falls within the compass or scope of that contractual language. So management rights, policies, rules, starting times, right? I mean, I have employers who would change their starting time. Maybe it's because of a customer. I had an employer who, no lie, canceled a shift on a Thursday in a week, and the union claimed it was a layoff. Okay? All right? And we had to face litigation over that. So the board is going to take a more, and the other thing about collective bargaining, remember I talked about the two policies of the National Labor Relations Act? Employee choice, what was the other one? Promotion of collective bargaining. What's promotion of collective bargaining? Fostering labor peace. What does that mean? Reducing conflict, right? Labor peace means less conflict. So if we negotiate something, we don't expect to be litigating for the entire life of the contract. We expect there to be labor peace. We give up things to get management rights. We give up things to get explicit provisions in the contract. So this decision came down in September. A bunch of cases went to what's known as the Division of Advice in Washington that advises regions on how to deal with new rules. I've had one case that has essentially been taken care of as a result. We were headed for trial on December 17th, and we're no longer headed for trial because of this case. So this is a really significant decision for unionized employers, one we've waited for a long time. All right, so what's next? What are you concerned about? Like, you know, what do you want to see changed at the NLRB? Everything, right? But what we reasonably expect to be coming down the pipe in the next year are decisions first concerning more about employer property, really. The Purple Communications case, does anyone remember what that case was about? Ray does, Chris does. Email system, right. So, and Liz is actually, you know, a client. She's not somebody who works in the department, so she remembers that. That's awesome. The board said in Purple Communications, overturning the register card decision, that you could not designate your computer systems, your email systems, to be company property to be used only for business purposes. That if you gave employees access to the email system, you had to allow them to engage in union or other protected concerted activity on those systems. Okay, which is bad enough. But the NLRB said this also. They said, but you can force them to only do that during their non-working time. So you can restrict their union, other protected concerted activity on your email system to their breaks, lunches, time before or after work. And what did that lead to? The realization that no one monitors any of that stuff with respect to employees. No one, you know, I'm sending personal emails all the time. I mean, no, I'm working very hard all the time, but seriously, do we really know when people are sending these emails? Do we really know when people are going on, you know, the internet and, you know, getting on Facebook or whatever it is? So it created this rule that effectively we just had to hand over our computer systems, our email systems, to the idea of protected concerted activity. The board also said you can continue to monitor your systems consistently, but there have been a number of cases where the board has said you're surveilling people if you look at their union or protected concerted activity on your email system. So it's been a big mess. That is a case we've been waiting to be overturned. It likely will be. I mean, hopefully I can predict that. And I think that will, again, be not only an acknowledgement of a proper, you know, idea of what employer property is, but an acknowledgement of the reality of organizing. That union organizers are not using your email system. Trust me, they're not going to be very successful if they're doing it. Organizing has moved on. The board is likely to revisit its assertion of jurisdiction over charter schools, which is very controversial in a number of ways. The board doesn't have jurisdiction over political subdivisions of a state. Okay, it's a federal law. It doesn't govern state government. So there's no mini labor law here in the state of Colorado. The board can't assert jurisdiction over, Governor Polis or anything like that. Charter schools are in that area where there's sort of a grayness in whether or not they're a public entity, and the previous board had asserted jurisdiction. They're likely to revisit that this year, and again, stay in their lane, sort of go back to their traditional jurisdiction. My favorite topic, of course, is Scabby the Rat, because I love Scabby so much. Or, other things like inflatable Mothra, like they had down at the RTD. I don't know if it was Mothra. It looked like a cockroach sort of moth thing. All this idea that street protests, the banners, the things that unions have done historically to stay away from the idea that their conduct can be regulated by the federal government. So all of this stuff, the Scabby the Rat, the banners, the other inflatables, the funeral procession, the death of the American worker, all of that is an attempt by the labor movement to not be regulated. When they assert that pressure against you, a neutral employer, to get you to stop doing business with the employer they're mad at. That's basically what that's all about. It's called top-down organizing. They're trying to get you, the property owner, to stop doing business with this company because they're non-union. That's what it's all about. And typically, the unions are not supposed to be able to do that. Unions are supposed to be able to protest against the primary employer. But the labor movement found this loophole that if they're not, and I always say, taking a piece of paper and attaching it to a stick and marching back and forth, that's picketing. They're saying that conduct can be regulated, but Scabby, the other things, the funeral processions, that's not conduct. You can't regulate that. All right, so hopefully the NLRB is going to look at what they're actually trying to do. Are they actually trying to get us, the neutral employer, to cease doing business? If that's the case, then it's conduct that can be regulated, hopefully. And finally, we expect the NLRB to finally issue its joint employer rule to really clarify this idea that there has to be active co-determination of terms and conditions of employment to declare you a joint employer. Again, having dealt in the franchise world a little bit, one of the things that's so troubling about this idea of indirect control is that, franchises are sold with the idea that there's going to be uniformity, right? You're not going to walk into a McDonald's and buy a roast beef sandwich. Or maybe you are now. They change products all the time. But, your expectation is you're walking in and there's going to be, 3 or 4 people at the counter. They're going to be in a uniform. The fries are going to be cooked in a particular way. It's going to be open certain hours. All of those things are elements of what makes a franchise valuable, right? That's why you buy the franchise, because of that expectation that it's, it's going to be the same here as it is in Des Moines. And the NLRB going into that area and saying, that means you're a joint employer with McDonald's corporate is something that clearly has to be dealt with, because obviously it's infringing on this idea. And the whole idea of labor law being a balance, right? We're an economy that we want to encourage businesses to create jobs. We want them to be able to do work. Strikes don't shut down industries. That's not the way we do it here. Balance the right of employees to engage in protected concerted activity against the legitimate right of all of you to conduct your business. That's where the NLRB should be. And I think this year they have been there. Don't get too comfortable though, because it very well could be changing within the next couple of years. And when it does change, all I will ask you is that you realize that I'm just the messenger when I tell you that the agency is doing these crazy things. I'm not the perpetrator, okay? So with that, I'll open up for questions.
I have one.
Okay.
Do you see the union coming after public sector employees due to these changes, and if so, what will that look like?
So the question is do I see unions coming after public sector employees as a result of these changes? And what does that look like? And I think it's undoubtedly yes. I've done more work in the public sector in the last 3 or 4 years than I've probably done for most of my career, except when I was in the public sector. What is happening is sort of a weird convergence of politics and the ability of labor unions to affect elections in small localities and counties, and this idea that they should then also have a right to organize all those county or city employees. And so it's a really interesting dynamic, because what happens is, and in Colorado, so and I think Arizona as well, there's no innate labor law. In Colorado, counties, cities have to decide whether or not they're going to authorize collective bargaining. And the way they do that is they pass ordinances and they say, we're going to authorize collective bargaining. So I've had these situations where municipalities have passed these ordinances because a couple of county commissioners have been elected by the labor movement, and then they do that, and people organize and say, hey, wait a minute, we don't have to negotiate with them about our terms and conditions of employment, do we? I'm like, oh yeah, that's part of the deal. So there's a real interesting dynamic going on there, and that's expanding. I expect that to continue, certainly, regardless. And part of that is also being driven by the reduction in labor and union membership across the country. The public sector employees are viewed as much more welcoming and favorable to labor and to a unionized environment. So I do see that expanding and continuing to expand. Any other questions? Concerns, thoughts? Yes, David.
Can you talk about how the MV transportation case affects the board's deferral practice?
So yeah, good question. David asks, is MV transportation that I talked about changing from clear and unmistakable waiver to contract coverage, did that affect deferral? Deferral is this idea that the NLRB will defer prosecution of an unfair labor practice if you have a collective bargaining agreement to grievance and arbitration and allow the parties to work it out. And immediately after the MV transportation decision came down, the General Counsel issued a memo that said, you need to look at whether or not these cases are appropriate for deferral, even if you're not going to dismiss them outright. So that is greatly affected and hopefully will increase deferral. And we like deferral, us unionized employers, because it again forces the union to have skin in the game. They have to pay for their representation, so they have to make the same cost-benefit analysis that we do. So that's been expanded under MV transportation, and again, hopefully that will continue. Great question. All right, thank you very much for coming to our breakfast, and hopefully you'll come when we start them up again. Happy holidays. Great way to start the holiday season, talking about the NLRB, most exciting agency ever, and thank you for attending. Appreciate it.